All right, whenever you're ready. You're good.
Thanks, Nate. So I will call this meeting of the Working Group on Medical Records to order at 10:03. And I'll note that some of our members are going to be late today. Some of our members that have power issues and contacted us. And we did have a couple illnesses as well. So while we are a small group today, I know those who may not be able to listen in right now, who are having power internet issues because of the storm, will be able to catch up later. And we look forward to their comments to be provided when they're able to be back due to illness, power, what have you, to let us know what they would like to participate in. So Representative Quinn will join us a little later today, hopefully. He had some commitments this morning and will pop on as soon as he is able. The first order of business is the approval of the minutes from our last meeting. Have folks had a chance to take a look?
Yes.
Is there a motion?
So
I motion.
Okay, is there a second?
I'll second.
Second.
Okay, any comments on the minutes? Okay, no comments. I'll ask for a vote on approval of the minutes. All those in favor?
Aye.
Aye.
Okay, so our next item is discussion on, and we did get the most recent version that Michael D'Amico drafted that was sent to everyone at 9:24 or 9:25 this morning if you did need to take a look at your emails. So we're all there. Michael, did you want to talk about your changes?
Sure. All I did, I mean, it was a little bit more than I thought it was going to be, but I made the changes to 19A 490B so that it would be consistent with the changes that I had submitted to 20-7C. It required a little bit more drafting than I thought it was going to, but my computer is running a little bit slow, so I'm waiting for it to pull it up. But everyone should have received a marked up version and then an unmarked version. I'm looking at the marked up version. The first change that I had to do was to separate out the request made by a lawyer or other authorized representative versus a patient or a representative with authority to make healthcare decisions, so that we didn't run afoul of conflicting with federal law, which doesn't allow for search fees and per page fees for electronic copies. So we had talked about that the last time. That's a similar change that I had made to 20-7C that we spoke about in an earlier meeting or meetings. Then I added in a provision for the form. So hopefully we'll have an opportunity to discuss a statutory form. That's one thing that I hadn't had a chance to submit, but I'm sure that will be relatively easy for us to put together some acceptable statutory form. Then I added in the words complete and legible. That was consistent with the change that we had made to 27C. I added in imaging studies. Again, that was to bring it more up to date. I think an earlier version of 27C just referenced x-rays. This, for whatever reason, this particular statute didn't have x-rays in it, but I added in imaging studies. Then I added in a provision for electronic format, which was, again, to be consistent with 20-7C, and simply indicated that if it's requested in electronic format and the institution has an electronic format, then it needs to be produced in electronic format. But if for whatever reason the institution doesn't have it in electronic format, then it doesn't require them to get an electronic health record system, although I can't remember the last time I received a record from an institution that wasn't an electronic health record, but I nevertheless put it in there to be consistent with 20-7C. The portion that you see marked out in green, or at least on mine, it's in green. I didn't delete it. I just moved it because it didn't flow right. And that has all to do with tissue blocks and tissue slides and a patient's or a designated healthcare provider's opportunity to examine tissue blocks and tissue slides. So I simply moved that down to now subsection C. But my recollection is all that wording is the same as what it was contained in the current statute. I just moved it so that it would flow better. The next part you see in red were modifications that are the same as the modifications that were made to 20-7C. This likewise provides that a lawyer or other authorized representative can make the request that if it's a hard copy, it is limited to 65 cents a page for black and white, 75 cents a page for color. And if it's electronic, then 35 cents a page, but no more than $20. And then there's the accept part of it. And actually there's some wording in there. It should say business associate where it says or other party in possession or control, because I had made that change to 27C for whatever reason. I must have missed that. So where it says such institution or other party in possession or control, that should say or a business associate. And then it says may charge the amount necessary to cover the cost of materials and supplies for an imaging study that's not reproducible in electronic format. And then this had to do with tissue slides as well. So that language about original retained slides or tissue blocks, etc., is language that was taken directly from the existing statute. And then the rest of that is consistent with changes already made to 27C that were proposed. Let's see, if an electronic copy is available, then it has to be provided in electronic. If an electronic color copy is available, then that has to be provided. If it's in excess of 100 pages, consistent with what we had proposed to 27C, a search fee of $20 can be charged. And there's a requirement that it be provided within 30 days and also has a provision for the expedited copy within 10 days. Again, this is all similar to what was proposed in 20-7C. Subsection B is essentially identical to the provision that I had proposed in 27C. This is when a patient or a representative with authority to make healthcare decisions makes the request. The fees are as set forth under federal law, so we don't run afoul of federal law in that regard. So there's nothing different about that than what was already proposed. And subsection D, E, F, and G were already in the existing statute. I didn't change any of those other than changing the reference under subsection F, referring to subsection B instead of A because of the reworking of the format, but otherwise it's identical to the currently existing statute. And then H, subsection H, is simply the form, the HIPAA compliant form that we'll need to agree to. And then I is the same penalty provision that was proposed under 20-7C. So all I did was try to make 19A 490B consistent with the changes that had been proposed to 20-7C. And I think I covered it other than that one mess up where it should say business associate instead of other party in possession or control. So I'm happy to answer any questions, but that's a nutshell version of it.
Thank you. I know we're talking about a couple statutes. If folks could, and I appreciate you, like we go, being very clear on which statute. It'll help the folks who keep our minutes. It'll make their life a little easier. If we can all try to do the same to the best we can, our staff will appreciate it if you're talking about this statute, the 19A 490B or the 20-7C to the best of your ability. Jennifer Cox, you had your hand raised.
Thanks, Representative. The first thing I'd like to say, it's not really a question for Mike, and thanks for all the explanations. It's more of a concept. Mike's talking about these are parallel changes to what were proposed for 20-7C. I just want to point out, I don't know that there's been consensus about the changes to 20-7C, so it isn't a matter of simply applying them to the facility statute. And just for the Representative Conley makes a good point for the record, to be clear for everybody, 20-7C is a statute that applies to practitioners, and 19A 490B is a statute that applies to facilities. So they are not identical for various reasons, and they came up at different times in statutory history. About the proposal that Mike just went through, I want to point out a couple things. It isn't, as written, it is not HIPAA compliant, and it would be a mistake for Connecticut to go in a direction where we are continuing to create preemption problems for HIPAA. First thing is interesting, and perhaps only to me as a HIPAA attorney, you cannot require a specific statutory form to comply with HIPAA section 164.508 for authorizations. The federal law is very clear. If a document has all of the requirements of section 508, then you must accept it as a HIPAA compliant authorization. State of Connecticut's not at liberty to change that. So it is not a simple matter of agreeing to a form. We actually came up against this last year and the year before when some of the lawyers may recall we were working with the folks that do the practice book changes. It was determined we would not have a form for Connecticut for litigation for HIPAA because it does not comply with federal law. And that would be true here as well. It's not an option for Connecticut to do that. Another concern about this is it reads like different buckets of people can have access to records. And in fact, we should be talking very clearly about copies of records. These statutes, both 20-7C and 19A 490B, are used by practitioners, providers, hospitals, the government to determine who can have information, not just copies. And when we start making distinctions about who's the right person and the person with decision-making authority or power of attorney or those things, we are actually making it more confusing when you are assisting your loved one at the hospital or at the doctor's office. And that is a direction in which we should not go. There's a lot in here that is going out of its way to make statements about things that are already set in federal law that aren't going to be changed. So because at the end of the day, I'm having trouble understanding, and we've talked about it, I've never heard an answer. I don't know what problem we're trying to solve, but I do know that this is creating more problems than it is solving. The problem with things that are not workers' compensation seems different, or although I haven't really heard what it is, I have heard folks come to plaintiffs' lawyers late, and it's hard to get records, and they might run past the statute of limitation. That isn't addressing that. This is addressing a lot of other things. For workers' comp, we've touched on a couple times, it's a different problem. Workers' comp system is like insurance, but it's not. They're outside of HIPAA on the comp side, but inside on the provider side. So unlike commercial insurance, it doesn't follow the same path of sharing of information, and that needs to be fixed. Understood. That's very different than creating a priority system for civil litigation, which I'm going to repeat because I just feel like it isn't getting through. If we prioritize civil litigation records over records for patient care, and we'll throw workers' comp into records for patient care because that's continuity of care, you will slow down records for patient care. So I'm still not sure what problem we're trying to solve, but I do know this creates more problems than it solves.
If I can just respond to a couple of those comments, Representative Conley.
Yes.
I don't necessarily understand why we can't agree on a form as long as it's HIPAA compliant. In other words, federal law may indicate what is required for a form, but as long as the form is compliant with federal law, then why can't there be a form? That doesn't make any sense. I would understand that we're not at liberty to create a form that's in conflict with federal law or in conflict with HIPAA. That would make sense to me. But I certainly don't understand why we can't have a form that's compliant with HIPAA. A form that's compliant with HIPAA wouldn't be problematic under federal law. We certainly can't come up with a form that's inconsistent with federal law. So, I mean, if there is some law that you're aware of that says you can't have a form that's HIPAA compliant, in other words, you can't have a form that complies with federal law that's set forth in a state statute, then I would like to see that law, but I'm not aware of any such law.
Yeah, I would say practically though, Mike, for that, having a form in statute might create some troubles. So that if federal law changed and you were to change a Connecticut form in any way, you'd only be able to do it during legislative session. I'll just speak for myself. I'm not sure if creating a form is the role of this working group.
Yeah, and I'm not, and I appreciate that. I was trying to respond to some of the concerns that were raised by Kyle, early on, and others. I don't remember if who else commented. It might have been Elizabeth. I don't recall everyone who commented, but there was a concern that the forms that were being submitted with a request were not necessarily compliant with HIPAA, and it was causing a delay. And so the suggestion at the time was, perhaps we can come up with a form to cut through that delay as long as we have a form that's compliant with HIPAA. I do understand the concern that if federal law changes, that would then require, a change in the statute. But one way to deal with that can be, or as amended by federal law from time to time, to the extent that it changes the form. But certainly I don't have an issue with not having a form. I'm just trying to respond to Kyle's concern, where there was a concern that not having a form results in more work, more labor, more time, more delay. And so that's the only reason that was part of the proposal. The other thing that Jennifer mentioned was that, we're creating more problems than we're solving. I'm not sure that I understand that. The currently worded version of 19A 490B in subsection A, specifically talks about a written request. So this is, not speaking, at least in that particular intro line, it's not speaking about a right to inspect. It says upon a written request. And so the idea here was to do nothing more than work with the wording that was there. Yes, it does set forth a different process, so to speak, a different process, not necessarily a process, but a different fee structure if it's requested by a patient's attorney or other authorized representative on the one hand, or whether or not it's a written request by the patient or patient's representative authority to make healthcare decisions on the other. But nothing was, in that regard, changed from the current wording of 19A 490B, other than making it clear that there's a different fee structure that would apply so that it's not in conflict with federal law. The portion that has to do with tissue blocks and tissue slides wasn't changed at all. It was simply moved to a separate section. So there was certainly no change in that as it relates to the patient or the patient's designated healthcare provider having an opportunity to examine tissue slides. So that wasn't even changed at all. So I'm not sure that I understand really the concern, there. I'm happy to listen to it more and perhaps get a better understanding of it. But the problem that's trying to be solved is the statute is way out of date. It's not up to date in terms of electronic medical records. It's problematic right now to use the federal system, as we all know, to request records if you're a lawyer. It's always a problem. We never get the same answer from the same facility or from the same vendor. So there's all kinds of issues that are creating significant problems. And the statute itself is just, woefully out of date and needs to be brought up to date. So I just wanted the opportunity to respond. So thank you.
Okay. Elizabeth, do you have comments? Oh, Elizabeth put her hand. Did we lose her? No, you're there. Okay. That was an internet issue on my end, Elizabeth. Sorry.
No, it's okay. I was a little bit slow on the mute button, so thank you. I just kind of wanted to build off of what Jennifer was saying. about the conflict between federal law and a state required authorization. There's also some additional like federal regulatory activities going on right now. More specifically, the Office for Civil Rights has a patient access initiative, which is looking at the barriers that are placed between a patient and accessing their PHI. One of those is requiring somebody to use a facility authorization. That's actually, unfortunately, a frequently found problem when they dig into these cases. And so, because not everybody has equitable access to the internet or to print a form or to even come in and fill out a form of the facility, that's why they really emphasize having a HIPAA compliant authorization. So we could go with a recommended form, and that may be something that we could do through like the health department or something, like a recommended form, but by no means can we, have a mandated authorization, because it's going to put providers in between, state law and federal law and guidance, and that's going to put them in a really kind of sticky situation. So I just wanted to kind of build off that. I'm certain Jennifer has more to say.
Yes, Jennifer, on cue.
Thank you, Representative. So I didn't mention the blocks and slides. I'm fine with that. I think that the tricky thing about that is it's not about records, right? And that's actually a CLIA lab issue, but we'll put that aside. Not that it matters about your understanding, because federal law will control. If there is a HIPAA compliant piece of paper that comes across, you gotta take it. So like Liz said, a recommended form might fix the thing that you're talking about, Kyle was talking about, but you cannot have the one true form in state law. That's why. It's just not allowed under federal law, because you must accept any piece of paper that's got all 10 things on it that make a HIPAA compliant authorization. The second thing is HIPAA distinguishes specifically between direct access requests under section 164.524 and authorized requests for third parties under 164.508. And these drafts conflict with that. So it's something that Mike and I agree on, which might be a great place to be, is the statute is woefully out of date. My point is the changes that are being suggested don't help. They actually confuse it more because of the way preemption works under HIPAA. It isn't one or the other. It's what's ever best for the patient, which is often hard to determine. And these statutes are used to determine if you're going to talk to family, if you're going to talk to the adult daughter that's helping with medications. All of that is true. So it does need an overhaul. This is Band-Aids that actually aren't helping the patient. They're not being put in the right places. So the problem we're trying to solve needs to be a tactical problem, not it's out of date. That in and of itself isn't the problem. So we need to identify the problem that needs to be solved, and then it does need an overhaul, but not one that causes confusion for providers, because I guarantee what Liz just said, it will cause confusion about who can get a record when and who that is and why, and it won't just be for copies. People will interpret it at the provider side as you can't talk to the adult daughter that's helping the mom with her medications, which is something that is just not acceptable for patient care. So there need to be a lot more HIPAA experts than on this call to fix it in a HIPAA compliant manner, because we are using a statute that was written far before HIPAA that should have been changed a long time ago. It has been the position of many of the provider associations for a decade that we need to update these laws. Agree. Updating this law by sprinkling things in that are not HIPAA compliant and might be preempted is just going to cause confusion.
So if I might comment, Representative Conley, just briefly.
Let's see if anyone else has comments, and then we'll save your hand up for a moment. Does anyone else have comments on the original presentation, so that your thoughts are heard appropriately? Is it Lane?
Lane.
Lane.
Hi, everyone. I just want to echo a lot of what Jen said. I'm the executive for the State Medical Society. I am by no means a HIPAA expert like Jen is on this. But I do want to say, a lot of what this focus of the conversation has been, it's been on large hospital systems. But we do have to remember that these statutory changes that we're making impact small provider and physician offices too, where there are not dedicated staff looking at medical records. We're pulling someone off of clinical care, we're pulling someone off of front office staff to respond to these medical record requests. And if we are prioritizing litigation over patient care and workers' comp issues, there is certainly going to be a backlog. Some of our physician offices are still solo providers in the state, not a lot. It is a dying breed, but they do exist. There are small offices. And I think I just want to make everybody aware of the fact that, we're looking at a one-size-fits-all approach, but it may not work for some of these small physician offices. They just don't have the staff to always to prioritize these types of requests. And I just want everyone to be cognizant of that there are small offices that we're talking about in this state that are on the brink of survival, and anything we do to sort of upset that flow could push them into further consolidation, which I don't think anybody in the state is looking for.
Any other comments? Susan, and then we'll get to Michael.
Hi, thanks. I'm not sure now is the time, but I did want to address the workers' comp aspect of it. So I don't know if we want to come back after Attorney D'Amico has an opportunity to talk a little bit more about his proposal.
But why don't we do that? Sure.
Okay.
Michael.
Thank you. Just a couple of quick comments. I think what Elizabeth had said about a recommended form sounds like a good idea. If we want to have a form, maybe it should be a recommended form so that healthcare providers can feel comfortable that this was, this is a form that's been recommended pursuant to statute, and it wouldn't cause the issue that Jennifer is concerned about as well. So that's certainly an option. And then lastly, there was, I certainly understand that HIPAA on the federal side makes a distinction between direct access and third-party access. But as long as the statute that we're creating is not in conflict with federal laws and something that is more restrictive than federal law, which I don't see these changes being more restrictive and therefore in conflict with federal law. It works side by side with federal law. But if there are specific recommendations that Jennifer has in terms of the proposed draft, that is something that I have the opportunity, and then all of us have an opportunity as a working group to consider, that it's certainly a good idea to get differing perspectives. I just haven't seen it. So.
Does anyone have additional comments on 19A 490B? Great. Does anyone have any additional comments from prior days on 27C? Now moving on to the workers' comp statute. Does anyone have any comments? We'll go to Susan for the first comment.
Thank you, Representative Conley. So my name is Susan Schaffman. I'm the Executive Director of the Connecticut Orthopedic Society. We represent approximately 240 orthopedic surgeon members here in Connecticut. And I did want to address the workers' comp issue because I do feel that that's totally separate from what we've been discussing, as other people on the call have noted in prior discussion groups. And I would like to say that the orthopedic surgeons, you work closely with the Workers' Comp Commissioner, and we'd like to have the opportunity to continue to work with the commissioner to perhaps maybe revise a professional guide for attorneys, physicians, and other healthcare practitioners. That is the guidelines, that is kind of a doctrine, right, that governs the orthopedic surgeon community or any other physician taking care of a workers' comp patient. I would also like to point out, there is no charge for medical records, right, for workers' comp, and that 30 days for medical reports it's really, there's really an incentive for the treating physician to get those reports in, one for reimbursement, but also for having carriers continue to refer patients to them. So it is in their best interest. Again, we haven't had notification or received any type of indication from the Workers' Comp Commission that this is an issue. And so we would like the opportunity to circle back with them to see how we might be able to revise this. There is a working medical advisory group panel as well as a legal advisory panel. On the legal advisory panel, the workers' comp, there's administrative law judges. So I think that we can get those issues addressed in that venue.
So, those groups there have been discussions for a couple of years on this issue in those groups, which is why this working group was created, because those issues have not been resolved. And I would say the continuity of care is probably the most concerning, not as much the referral of more patients to the doctors. It is that if the doctors are not getting the records to the insurance companies and to the claimant's lawyer, the claimant is not allowed to get that MRI authorized. The claimant isn't allowed to get that surgery authorized or get the second opinion exam. And the delay is holding up the continuity of care, which affects the injured worker and also affects the insurance company at the same time. So, Susan, were you able to watch the meeting from last meeting?
I'm sorry, I was not. I read the minutes, but I didn't watch it. No.
Yeah. So the proposal discussed, I know there's nothing yet in writing. The proposal discussed the change we had talked about if the 30 days was reasonable for the providers, and where no providers had followed up and said the 30 days was unreasonable or that they needed more time yet. But I still would like to say that folks who represent providers can give us that feedback if they need additional time with the third party administrators, or if the 30 days is still reasonable. The penalty that was discussed at the last meeting, if folks weren't aware, was to give the administrative law judges opportunity to provide a penalty at an informal hearing. And the first penalty could be just a letter, similar to the no-show letter that was provided when insurance companies or claimants may not, mostly insurance companies may forget to attend a hearing. So the first penalty being a letter after an informal hearing, and give the administrative law judges more authority if they feel it's necessary at that point. And I see Marie Gallahall unmuted herself. Marie, did I summarize that discussion appropriately?
Yeah, I was trying to find my little raise my hand tag, but I couldn't seem to find it. Sorry about that. But as I said the last time, we need to be very careful about putting too much work, I don't want to say work, but too much of this onus on the district offices, because just from being in private practice for 20 years, I can tell you that whether it was 30 days or 60 days or 90 days, getting records within those first 30 days was often problematic for a variety of reasons that I'm not going to go into. So I think that there is a problem in the workers' compensation forum, but as with so many things when you're writing legislation, you need to be very careful about the solution and the unforeseen consequences of any solutions. So I can certainly, Susan, talk to the chairman about working to revise the guidelines or bring that up at the next medical advisory panel meeting. But I think for this forum, there's more of an effort overall, not just, the unofficial guidelines that we send out, but to actually change something substantive. Is that true, Representative Conley? Is that an accurate statement?
Yes, I think that's fair to say. With this forum, I think the problem has been aware for years and years about how to help with continuity of care. And I think without the records in the workers' comp forum, no one can do anything. And that seems to be a problem that we need to assert. I think the chairs are open to the timelines and with the desire not to over swamp the commission with too many hearings. No, if we stick to the 30 days, if the third day expired, someone, either the claimant themselves, claimant's counsel, insurance company's representative, would ask for an informal conference. Then that informal conference would need to be scheduled. But if the provider provided the record in time, in that period of time, additional weeks, then that conference could very much be canceled. And then if it was still an issue by the time folks became in front of the administrative law judge, they could talk about it, and then the administrative law judge could make a choice as to options. I would hope that getting that with one or two letters of no-show, that would maybe get folks who needed to update their systems the process. But I'm open if Susan or others from the medical area have thoughts on how to handle that better, so we may make the right statute. But I do think the intent of this working group was to note that the current 30-day statute has no teeth in it. So when one does not provide the records, there's no recourse in the statute.
So Representative Conley, if I just question you a little bit, when you're talking about fine letters going out from the judges. Now, the medical providers are not parties to the action. That doesn't mean that we don't have some authority over them, but I just want to put that out there. And also, I have some concerns about fines coming from our judges absent formal litigation.
So the first letter could be a notice letter, not a fine letter, just like the no-show letter. Remember, with the no-show letters, we do have the please attend, and then there's the fine letters that are separate. I was seeing an alert by the judge as a first penalty that there's a problem, that there's been raised a problem at a hearing, and then maybe a secondary hearing. And I would agree that, we'd have to figure something out where the due process is made for the party who's not present. Susan.
Hi, yeah, I just wanted to say that definitely the 30 days was reasonable, within the orthopedic community, I can say. And as far as a possible alert of, over 30 days, I mean, that's something that I guess could be considered. But we were pretty strong in our testimony that we oppose the penalty portion of it for the teeth in the statute, if you will. Again, I just want to circle back. I don't know if this is a couple of large physician practices as it relates to orthopedic care of the injured worker, or if it's a large hospital system. But I also think that if it is one or the other or both, I think that it's an opportunity to sit down with, the key players in those facilities and or in those practices, along with some of the legislators. And I know that that's something that was presented to me as well. So if that's something that could be helpful, even if we take the discussion back to the workers' comp commissioner and engage these parties, that might have a greater impact on the delay of records that results in problems with continuity of care. We're more than happy to help.
Yeah, and I would say for the record, I think there's a lot of the larger providers are able to have liaisons, are able to have someone that when either an insurance rep or a claimant's rep is having issues, they're able to rectify those for hearings and for matters. I would say in our time of more providers getting into larger groups, and the records being controlled by the larger organization, be it the hospital or the larger group that might be, multi groups or multi locations. Even some of these are now getting into multi states. The records providers are not that liaison or not that local person, so that the contact is more of a less friendly face and more of a computer face or a corporate face. And getting that liaison has been difficult for continuity of care, that I think has been expressed on the claimant side and the insurance cut side. I would say there are some large hospital networks that are great, and there are some large hospital networks that with workers' comp records I think are probably treating the records under the other statutes we were talking about and not the workers' comp statute. And maybe this working group will assist because there are some representatives for them on. And hopefully they can assist in the issue of the workers' comp continuity of care and the records being needed under the other statute number. So, Jennifer.
Thank you, Representative Conley. I spend an unnatural amount of time thinking about this. I find it fascinating, and I think you just put your finger on what I was about to say. I think what's happening in the places where there might be a slower pipeline of reports or records for workers' comp is they are treating it like a regular record request because it's the system, the computer is agnostic to the fact that it's workers' comp as the payer. Workers' comp as a payer is a complication. It confuses the system because workers' comp itself is outside of HIPAA, right? So if you have Anthem or United Healthcare or the state health plan, you are going right, it's automatic. The payer's getting it automatically. And in workers' comp, there's a barrier. So what Sue said is right. And I recognize it's frustrating for folks who are doing comp and have seen what apparently for years is this jagged slowdown and it affects continuity of care. I will tell you as a provider side attorney, and as Sue said, and I think Lane would agree, we were not aware at the provider side that that is glitching. And I do think it bears effort on the provider side to work with Workers' Comp Commission to try to find a better way to do this. If there's a way to be sure that that flow of information is not treated like a third-party request, because it's not, it's a payer request, but the payer's outside of HIPAA, that probably solves a huge amount of the problem you're seeing, which almost certainly wouldn't require legislation. And the other question I have, which I asked before, I'm not sure I recall a clear answer. The statutes in workers' comp right now talk about reports, right? Someone knows they are writing a report for the Workers' Comp Commission versus records, which is actually an entirely different thing. And I'm wondering if you're talking about one or both, because the privacy issue, all the HIPAA issues come up when it's records, not the report. If it's the report, I got to say that should be easier for providers to put in a different bucket, a different silo to try to get past this continuity of care problem that's being created.
Yeah, I would say the biggest issue is I don't see the difference as much between report and record. What we're looking for is the plan of care. And I know, and in my mind, there is when one sees the records, when they come through and you see everyone's medications from all their ailments, not necessarily why they saw this orthopedic doctor. And I'll say orthopedic because most work injuries are bones and joints and things. But you'll see, someone has high cholesterol or is on this or that or what have you when they have C-section. What the continuity of care problem is looking for the plan of care. Are often the entire record provided? Yes. Is that necessary under the statute or needed for the continuity of care? No, it's not needed. But I would see, and that's why I said kind of one of the things we say is the computer says no. When you ask for the record or the report, when you ask for the plan of care, you're often getting the full record as if it was a personal injury case or a med mal case and the timelines. And while that's wonderful information, it is not really what's needed for the plan of care.
Thank you. That's super helpful. I honestly think there's a misunderstanding in how the system is being mapped for just the reason you just said, and it's being treated like records, which is creating a privacy issue. Because just like you said, let's say you went to the orthopedist for something work-related, but something not work-related, and now they're trying to parse it. That's why it's getting gummed up. So that's a great clarification. I'm going to repeat, I support what Sue said. I actually think providers being more focused on this in a way that they haven't been. I apologize, that's frustrating because this was the first I heard of it when we started having these conversations, that there's a systemic issue in getting prior approval for care. And that is not something we had focused on. And so with focus, I'm hopeful that there are solutions that don't require a statute, but I don't think this has been worked on the provider side, and I think it could be.
It's good information. That's good that folks are willing and are now aware of the problem. That I think has been a problem. Noting Miguel Hall did work on the insurance company side. I've worked on both sides and seen the problem on both sides for many years. And I know that while folks are very good in the workers' comp end about getting together and working on programs, this might have just been a conversation that folks thought they were complying and didn't realize that the continuity of care problem has existed for a while. So we'll continue to talk about that. Are there comments, thoughts on any of the statutes we've talked about? I do like to run a tight meeting, so this is wonderful today. I don't mean to stifle discussion, but if there's no comments, and again, asking again, comments, thoughts, discussion, our time together outside of legislative session will be coming to an end. It doesn't mean that we can't continue to work, but we will have to make a discussion at the next meeting. So I'm going to give some timelines that I think are reasonable, and we'll talk about it. So if anyone has any new proposals, any updates to their current proposals, or want to make sure that the chairs have your current proposals, if folks could email those to Nate by Friday at 4 p.m. That way we'll make sure that we have everyone's current proposals, updated proposals on the multitude of statutes we've been talking about. And that would give Mike, Chair Quinn and I an opportunity to review everything, make sure we didn't overlook anyone's proposals. And if your proposal is no changes, I'm going to say we want to hear that too. Or if your proposal is we need more time, or your proposal is this is my changes, please get us your proposals. No proposal is unreasonable, unfair, so we can take a look. We will have our last meeting outside of legislative session will be January 30th, which is 2 Tuesdays from now. So that gives Chair Quinn and I a week to look at everything and discuss. If any member has any suggestions as to what they think the working group should vote, or if you think we should take more time, please provide that information. We anticipate having votes on January 30th at 10 a.m. And this committee does run from 10 to 12. So if you did need that extra time to free up your schedule, 10 to 12, January 30th. And then we will be in legislative session starting the next week. So no thing that we do vote will become law, just to be clear. Anything that this committee votes on would be given to the appropriate committee for to be raised by any committee for public hearing. So nothing that we do will actually become law right away without full comment and full working of others. We also could choose to continue to work on things during legislative session or for longer. So please do consider that, and please provide your thoughts or comments. Does anyone have any questions? Is the Friday 4 p.m. deadline reasonable? Seeing head
Yeah,
shake, yeah.
I have one question, Rick Silver.
Sure.
If we don't do a form, how are we solving this problem? In other words, if there's not a form that we can agree on, how are we solving the problem with the provider saying, I don't like your form? Or providing a form that we don't think is agreeable?
So as we are 2 weeks from legislative session and no form has been presented, if it's your idea to have a form, that is a fair idea. But at this time, we do not have a form presented or discussion on a form presented in legislative session quickly coming upon us, which starts February 8th. So forms can come through the department, the insurance department, the Department of Public Health. Forms can come through regulation. They do not have to be in statute. And very few forms, I believe, are in statute in our state. But creating a form or discussing a form is a fair and good idea. What that form is, I think we will not get, this working group may not get that by next Tuesday.
Thank you.
Layton, sorry.
That's it. I just have a question on voting. So let's say by Friday at 4 o'clock, we have 3 or 4 different proposals that have been submitted. Is it going to be a straight up and down vote on each proposal? How do you envision that working on the 30th?
So I envision the chairs having discussions and then providing items for discussion and vote to the group. So the proposal, there may not be a straight up and down vote. There might be a proposal by the chairs that incorporates multiple things. There might be a proposal to continue our group discussion for longer. The chairs have not made any decisions, except we'd like to make sure we see everyone's proposals so that we can look at them. But I would like to say, if everyone can be of attendance, I think it would be very helpful. Any other questions?
So will you send drafts around before January 30th, before the next meeting? That's the goal of the chairs.
I don't think the goal of the chairs is not to surprise anyone. But if we don't get things until last minute Friday, how early will the group get things? As early as the chairs are ready. The goal is not to surprise anyone with a 20-page document 2 minutes before a meeting.
Great, thank you.
Any other thoughts or comments? Okay, seeing none, we will end our meeting early. It is 10:53, and I'll give everyone a little bit of time back to their day. See you guys on the 30th at 10 a.m.
Thank you.
Thank you.
Thank you.
Stay well.